Can I go ahead and just give a brief opening or? Okay. Oh, okay. All right. Thank you.
First, and there's no other changes to the agenda.
Okay. With those changes noted, we'll approve the agenda for today. Next on the agenda is the approval of minutes. I will state for the record that I have read through the minutes from the last meeting, which I we had one stand-in for me and my son because of conflict of interest, and then I handled the rest of them. And I read through those minutes, and I hereby approve those minutes. Okay. We're ready to start the public hearing portion, and we'll start with case.
It's the name and address of the.
Mr. Bowman, on the minutes, excuse me, everyone, do you see a vote button that just came up?
Is it on this?
Yes, sir, it should be.
Is it green?
Yes, I believe.
Push that.
No, I'm sorry, on the laptop. I was trying to do it for you.
I'm sorry. Let's see. Under mover?
Yes, sir.
Cap mover?
Yes, sir.
Okay.
Okay. So allow me to change to item 8.9, I'm going to up now, so thank you.
Okay. All right. So we're starting out of order with case number CE 24312CA, which on the agenda is 8.9.
And that's correct, Your Honor, and because today is the first time we're doing a team's approach to one of this particular matter, so it's kind of the guinea pig today. Earlier, before we went on the record, staff made it clear that to make sure the audio is recorded adequately, we'll need to, I guess, do all our speaking one at a time today. So when you're done speaking, staff actually asks to make sure the microphones are working on our end, same for Mr. Moore, and same for the respondent and their attorney. And so it might go a little slow here today, Your Honor, and I just ask that you be patient with us on that. And I guess we'll start today. The city, Mr. Ed Moore will give an overview like it's typically done.
Mr. Moore, you may proceed.
Good morning.
Good morning.
This is case number CE 24312CA. My name is Ed Moore, Code Inspector, City of Fort Walton Beach. This case pertains to 177 Beale Parkway Northwest. According to the tax records, the owner of said property is David Chenault. 23 days ago, on April the 22nd, 2024, the property was found in violation of Code Section 20300, Commercial Activity, and Code Section, Land Development Code Section 50432, prohibited operation of a livery vessel rental business and commercial boat fueling and storage yard from a residential zone property. On May the 3rd, 2024, service was obtained for the notice of violation. And on May 7th, 2024, reinspection of the property found the violations had not been corrected. On May the 8th, 2024, service was obtained for the notice of hearing. And today, on April 22nd, 2023, on May the 3rd, 2024, and on May the 8th, 2024, photographs of the violations were taken. And as of today, May 14th, 2024, the property is in compliance. As of today, May 15th, 2024, the property is in compliance. Staff will be requesting an order from the special magistrate due to possible repetitive reoccurrences of the violations at the subject residential property. At this time, staff would like to enter the exhibits into the record. Exhibit A is a case history report. Exhibit B is a list of exhibits. Exhibit C is a notice of hearing and proof for repeat violation and proof of service. Exhibit D is a notice of violation and proof of service. Exhibit E is a copy of the inspector's qualifications. Exhibit F is a copy of the tax record showing the property's ownership. And Exhibit G are photographs of the violation. Staff is requesting acceptance of the findings of fact, conclusions of law, and issuance of Order 1 in compliance, including the $325 administrative fee.
If I could interject for a second, Your Honor, the proposed orders that you received, actually, I've made some revisions to this morning and I'll revise it further after the hearing here today to make sure the findings of fact line up with the actual findings in the hearing here today. And so if you have something before you, I've asked you don't enter at this time, we'll want to make some changes to that.
Thank you, Mr. Burke.
Would you like to see the case file? I think Bert has the photographs in there somewhere.
Do you mind if I narrate for Ms. Betts what's going on?
That's fine.
So Ms. Betts, you're going to have a chance to interject any objections here in a minute. The magistrate's just reviewing the exhibits, and then those are the exhibits that you've been provided by email this morning. And so in a minute here, we'll hear any objections that you have to it. Okay?
Understood, thank you.
These are just photographs taken. Oh, sorry.
Okay, Mr. Moore, I noticed that the photographs are not included in the file. You are showing them on the screen.
These should be, look on the front inside cover
But, okay.
and on the back.
Oh,
It all prints out as a big Adobe file.
I got you. Okay, yes, I correct myself, there are photographs on the inside. We're using aerial photographs.
And I guess Ms. Betts, because we have a weird stilted procedure here today, Your Honor, I did tell her that she would have a chance to object. And Ms. Betts, do you have any objections at this time to the exhibits?
No, I've reviewed exhibits A through G, and I have no objections to any of the same. Thank you.
Those exhibits will be admitted without objection. Okay, Mr. Moore, thank you, sir.
The photographs, basically, 177 Beale has, it's unique, it has a right-of-way easement next to it that you can walk down to the water and basically access view of the property without entering the property. As you can see in the top right photographs, that's the entrance easement. I believe it's a easement so the city can get back in there for drainage purposes. But anyway, the photographs are all from Beale looking east, and the various watercraft at the dock and on the property, as well as the posting of the notices for the property owner. And the last one, I believe, is in compliance. Bert wants to bring that up. And you can see the boat dock's pretty clear, and there's no commercial related pontoon boats or watercraft for the property.
Mr. Moore, anything in addition? Anything additional that you wish to add?
I will say I've spoken to the gentlemen that were there, and they were pretty cooperative, and they explained that they were finding a commercial location and that they they wanted to have it done by the date of the hearing. This was last week, and when I was out there for the compliance inspection, the young fellow that was still there, he explained that they should be at their new commercial location and that they won't be bringing any more of the vessels back to this property, because he understands why it's a violation.
And specifically, explain what the city is asking special master to do. I understand they're in compliance, but you want some assurance that that compliance continues. And is that to impose a potential fine if there is a non-compliance?
No, Your Honor, so all we're asking to be done today is to make the findings of fact, and I'll ask them some additional questions here in a minute, just to make sure we get everything that needs to be in order. We're recent with the findings of fact made, recognition that property was in violation, it's now been brought into compliance as of today's date, but it was a violation at some point in time. And then I do believe there's, is the staff waiving the fines or stipulating to fines being waived?
What happens is, if we get the order one in compliance, that'll give us a chance. If it does, commercial operations take place again at the property, we can go through a hearing notice without having to serve the notice of violations, as well as the fine will start on the day that we see if there's commercial activity on the property, if it's up to the special magistrate at the hearing. But today, we do want the administrative fee for the $325.
So it sounds like staff is asking that any fines that would have been accruing be waived. They are asking for the administrative fee though, and there's nothing in there that you'll be entering, like they won't automatically be in a violation of your order and have fines accrued in the future. There will be language in there that expedites the procedure in the future though, if a recurring violation occurs. So it sort of acts like an order one in that regard, and that they can go straight to the order two process. Is that correct? Yeah.
Correct.
And then, so it's an order one in compliance. So it's order one being entered, but it's recognizing that they're in compliance today, and that staff is only asking for the administrative fine, or not fine, administrative fee.
Anything else from the city?
If I could ask him a few questions. So Mr. Moore, I know, I believe in the packet it did have a list of your qualifications, but can you just state how long have you been a code enforcement officer for the city?
For a total of 24 years.
And on April 22nd, you responded to a complaint that was made by a member of the public. Is that correct?
Yes, sir, but I recall it came through the city manager's office from the citizen complaints of the neighboring properties.
And so it came through the normal channels?
Yes, sir.
And you went out on the property and you, at that point in time, took the pictures that are entered into the record, and determined that there was a violation of the city code, correct?
When I visited the property, I believe on April 22nd, the amount of pontoon boats there, as well as the way they were docked, led me to believe it looked like a commercial livery vessel operation.
Do you remember approximately how many pontoon boats were on there?
Off the top of my head, without counting, I think I saw 6 engines, which I think each boat had 1 engine.
And but there was no signage on the property at that time indicating the business?
No, sir, I didn't see any signage on April 22nd.
Okay, and then subsequent to that, you then provided notice of a violation, is that correct, to the owner of the property, Mr. Chenault?
Yes, sir, I sent a notice certified mail, regular mail, and I also posted it on the property so that he'd have the information quickly.
And at some point in time after that, you did receive contact from Mr. Chenault's attorney, correct?
I don't recall when.
By email?
Yes, sir.
She emailed you within a few days, correct?
I believe it was within the following week. Yeah. I've got a copy of the email, but I didn't bring it with me.
And so they did acknowledge receipt of the notice, and then did you have further communications with their attorney after you filed the notice of hearing?
I believe Megan in the email explained that they needed more time and they wanted to bring the property into compliance and they wanted an extension till May 30th, end of the month.
But then after that set of emails, and then you provide the notice of hearing, correct?
Correct. After the reinspection date, I scheduled it for today's special magistrate hearing and then sent the notice of hearing, like the notice of violation, certified mail, regular mail, and then posted it on the property.
And to your knowledge, Mr. Chenault has been provided notice of today's hearing, correct?
To my knowledge, yes, sir.
All right, no further questions, Your Honor.
Thank you. To respond, have any questions, Mr. Moore?
Good morning, Mr. Morgan. Yes, I just have one quick question for you, sir. How are you today?
Good morning, good.
Good. Sir, now, and just to be clear for the record, Mr. Chenault is allowed to keep personal boats on the property, correct?
Yes, ma'am, he's allowed to store personal boats on the property, correct.
Okay, and I just want to be clear that of the 6 boats that I believe you initially counted that were there, at that time when you made that determination of those boats, you didn't know if any of those were personal versus commercial, correct?
No, I didn't know if they were personal or commercial, correct.
Okay, that was my only questions. I guess it was 2, so thank you very much.
Thank you.
And so I'm going to redirect.
Yes.
So Mr. Moore, did you ever have any conversations with any of the individuals on the property out there?
The times I would visit and speak to the gentlemen working there or on the property, they were friendly, but they didn't elaborate. But I would explain to them the nature of the violation and what needed to be corrected, and there wasn't much feedback from them.
Did you previously last fall deal with the sign issue, where the city of Fort Walton Beach on the same property with a signage issue dealing with the livery business?
October 2023, we had a complaint for the sign, and I believe I had a picture. I think it's the first picture in there. Of course, being October, and that part of the year is pretty chilly, so we don't see a lot of the livery vessel businesses operating, but the sign that they placed on the property advertised the rentals, and they couldn't have that type of sign in a residential zone property.
Rentals of boats?
I believe that's what it says. I don't know if Burke can blow it up, but it gives a name and a number of it.
From your memory, did you say?
Yes, sir.
Okay. And so at that point in time, you were under the belief that they were, at least as of October, operating business, but then they shut the business down for the season. Is that correct?
I was under the impression they put the sign up to advertise the business, which they couldn't have on the property, but the amount of boats there were still in the front yard. They weren't actually in the water. And I believe they looked all properly registered, so they had to take the sign down, but it gave me an indication that they were probably gonna use the property for that business.
Were they you said there were boats in the front yard, were those pontoon boats?
Pontoon boats. You can,
And all the boats you've ever seen in the backyard are pontoon boats, correct?
correct. And on the dock, in the yard, there are 2 boats there. When I spoke to the gentleman yesterday,
Were you gonna say you believe maybe 2 of the boats are for personal use? Is that what you're about to say?
right, I know that there are 2 boats there for personal use, correct.
Okay, no further questions, Your Honor.
Anything further from the city?
Not from the city at this point in time. I don't know if Ms. Betts, because she can't be in here raising her hand, might have some free cross or not.
Ms. Betts, do you have anything further for this witness?
I do not, thank you.
And this is all the city has to offer at the moment. Ms. Betts, do you have some evidence to offer today or comments?
Yes, Your Honor. I've got joining with us this morning Mr. Tyler Chenault, who is the tenant of the property and also the managing member of the entity that owns the pontoon boats. And I just would like to present to the court just a brief, couple quick questions, just showing that, one, they're aware of the issue. There was never any commercial activity as far as, people coming to actually leave anywhere on from his property. They were storing it for a short period of time and repairing some boats, but they have been relocated, and also to reassure this court that there will be complete further compliance based upon where the boats have been relocated. So if I could just call and ask him a couple quick questions to that effect, that would be greatly appreciated.
Certainly. Proceed.
Thank you, Your Honor. Mr. Chenault, can you hear me okay?
Yes, can you hear me?
I can, perfect. And sir, can you please spell your first and last name for the record?
Tyler Chenault is TYLERCHENAULT.
Thank you, sir. And I'm gonna go ahead and share my screen. And Mr. Chenault, can you tell me what this is a picture of?
My neighbor with like 3 boats and a lift for another boat.
Okay. And what is this picture, sir?
Those are all of my commercial boats that are at a different property at Marker 21 Marina.
Okay. And have they been relocated permanently, sir?
Yes, that's where we operated last year, and that's where we're operating this year as well.
Okay. And based upon the violation that you received, do you have any intent in removing these boats from this dock and putting them back at your property, sir?
Not for commercial use, no.
Thank you. Those are all the questions I have for you.
Just a question or two.
Okay, sure.
And I guess, Mr. Chenault, I'm Attorney Jeff Burns for the city. Can you hear me, sir?
Yes.
Okay. Prior to moving the boats over to the marina, as you indicated in that last picture there, were they stationed at the Beal property?
Yeah, the boats were temporarily at my property.
Okay. No further questions, John.
Anything further, Ms. Betts?
No, Your Honor. Thank you.
Okay. Anything further from the city?
Yeah, anything more than, I guess to
No, sir.
clarify, I guess the city is saying they're not going to be seeking any fines, as Mr. Moore indicated, and I guess the biggest issue will be just the wording of the findings and that point, Your Honor, and I guess there'll be the issue of the administrative fee, whether or not you want to impose that. The city's position is they want the $350 fee imposed, $325, excuse me, and I don't know if Ms. Betts has a position on that.
Ms. Betts, do you have any position on the $325 administrative fee?
My client does not object to the fee. Again, you know, they did not understand that they couldn't store the boats, but they now completely understand, and so they have no objection to the fee, the administrative fee.
Thank you. Okay, based on the evidence before the special magistrate, the review of the file, which has been admitted in evidence, and the testimony, we will find that there was a violation of 117 Beale Parkway, Fort Walton Beach, consisting of conducting commercial activities on residential property, specifically a livery vessel rental business, violation of the LDC section 5.0432 and 2.03.00. We'll find that it appears to the special master that there was at least 4 rental boats that were berthed at that property for some period of time, and there's no dispute as to that in the record. So based on those findings, we will enter a level 1 order of compliance. The special master recognizes that there's no dispute that the property has been brought into full compliance as of today's hearing, and that will be part of the findings of fact. And we will, because there's no objection, impose the $325 administrative fee. I think that's typically payable in, 30 days?
Yes, sir, within 30 days, yes.
Okay, which will be payable in 30 days, and Mr. Burns will draft a proposed order and will furnish that to me, but also Ms. Betts to you for your comment before I enter it. Okay? Is there anything further on this case, Mr. Burns?
Just to make sure for belt suspenders purposes, and I don't anticipate there being anyone in the crowd, but I think technically just ask for any public comment, and then if someone comes up, maybe we have to reopen your ruling.
Okay, I'm sorry to overlook that. Is there any public comment at this time regarding this matter? Okay, seeing no public comment, that is the ruling of the special master, Mr. Burns. You'll draft the order, furnish it to Ms. Betts for her comment, furnish it, any comments to me before I will enter the order, and I'll act accordingly.
And I'll get that to you today, Megan. Okay.
Thank you, appreciate it.
Thank you, Ms. Betts. Have a great day.
Thanks, have a great day.
Thank you, Your Honor.
Okay. Okay, we'll return to the published agenda at this point. I believe that would put under Section 8.1, case number CE 23126 UNO. And we'll hear from the city.
Rich Taylor, City of Fort Walton Beach Code Enforcement. This is case number CE 23126-UNO. It pertains to the subject address 20 Waynell Circle Southeast in Fort Walton Beach. According to the tax records, the owner of the property is Tammy Zingaretti. 345 days ago, on June the 5th of 23, the property was found in violation of litter and non-operative items, section 5.04.01, sections 7 and 9. On September 6th, 2023, service was obtained for the notice of violation. On September 16th, a reinspection of the property was found that the violations had not been corrected. On April 30th, service was obtained for the notice of hearing. On 5/1 of 24 and 5/14 of 24, photographs of the violations were taken, And as of today, 5:15, the property is still in violation. At this time, staff would like to enter the exhibits into the record. Exhibit A, case history report. Exhibit B, list of exhibits. Exhibit C, notice of hearing and proof of service. Exhibit D, notice of violation and proof of service. Exhibit E, copy of inspector's qualifications. Exhibit F, copy of tax record showing property ownership. And Exhibit G, photographs of the violation. Staff is requesting acceptance of findings of fact, conclusions of law, and issuance of an order 1, including a $325 administrative fee. Staff also recommends 12 days for compliance of the violation. This would make the compliance deadline May 27th of 2024.
Anything further?
I'm sorry?
Anything further?
No. I have some photographs.
Okay. Is there anyone, a respondent here for this particular case?
No.
Okay. Let me see your file, please. I don't need you to publish the photograph on.
Photographs are in here.
Thank you.
While you're doing that, Runner, I'll ask the clerk a necessary question. When something appears on the screen, does it appear to everyone on YouTube? Can they see it? Okay. That might be the only reason that I can say.
That's fine. Okay, I've reviewed the file containing the exhibits. The exhibits will be accepted into evidence, entered into evidence. Ms. Zigaretti has not made an appearance. Given that fact, there's no opposition to the entry of this order. We will impose a fine not to exceed $250 per day if the violation continues past what was the date? Beyond May 27, 2024. And we will adopt the findings of fact that have been presented. Mr. Burns, anything additional that we need to
I guess just recognize on the record if no one from the public is here to speak. So.
Is there anyone from the public here to speak as to this case? Thank you. Thank you, Ms. Tanner. Give you your file back. You may have filled in all the blanks on the order. I might be able to sign that one today.
It's a draft order. I'd have to redo it.
Okay. I think it's good as drafted. So you can send it to me later today.
I will.
Okay, thank you. All right. I think the next case, 8.2, is one that was found to be in compliance. So
Correct, yes,
on
we're skipping 8.2,
Pardon?
moving to 8.3.
Case number CE 23409-WIN.
Okay, I'm Robert Rhodes, Code Inspector, City of Fort Walton Beach. As he said, this is case CE-23-409-WIN. This case pertains to the subject address of 330 Oakland Circle, Northwest, Fort Walton Beach, Florida. According to the tax record, the owner of said property is Javerick C. King. The property was originally found in violation 258 days ago on August 31st, 2023. The case was brought before the board or magistrate on January 17th, 2024. The board or magistrate found the property in violation of maintenance general for failure to repair and maintain molded and discolored and deteriorated siding. Also failure to repair and maintain windows under 5.07.01. Subsection C for failure to repair broken and or boarded up windows. The board or magistrate issued an order giving the respondents until April 16th, 2024 to bring the property into compliance. An inspection on April 16th, 2024 found the violations had not yet been corrected. Therefore, on April 16th, 2024, a statement of non-compliance was filed. On April 23rd, 2024, service was obtained for the notice of hearing. And at this time, staff would like to enter the exhibits into the record. Exhibit H is the January 17th order of the board or magistrate. Exhibit I is the April 16th, 2024 statement of non-compliance. Exhibit J is a notice of hearing and proof of service. And staff is requesting acceptance of the findings of fact, conclusions of law, and issuance of order 2, including the $325 administrative fee. Staff recommends a fine amount of $100 per day starting on April 16th, 2024, the date previously set by the board or magistrate. And I believe we have a respondent here, so I'll see if they have any objections before we enter the exhibits into the record. Is Mr. King here? Do you have review the exhibits, see if you have any objections to the documents?
I just couldn't hear the last part as far as the recommendations.
Basically, the recommendations are that he issues a second order. You can ask him for more time, but we just basically went back to that.
Mr. Rhodes, would you speak up, please?
Sorry. But basically, these are the documents that you should have received: the notice of hearing and the statement of the order, the notice of hearing, and the statement of non-compliance. If you don't have any objections to those, we can get those in the record, and then you can discuss it with him. Or you want to review the documents themselves, see if they look.
I don't have any objections to the findings, other than I did find out that the window was not boarded. I thought it was boarded as well, but the previous tenant, I guess, painted the window pane white.
Okay, well, you can discuss that with him.
Your Honor, I think he's saying he objects to the order right now, but that's not an exhibit, obviously. So the order has the findings of that. I think you'll have a chance to challenge those here in a minute. Like you're not stipulating to that.
Okay.
So, yeah.
Am I agreeing to anything right now?
You're only agreeing to the pictures and you're looking at like the notice right now. Are you okay with that? Is that?
No.
Okay. Thank you. If you want to stay at the podium, is there anything else in the city?
Just to present photographs of the
Okay.
property.
Let's do that. I will find that there's been no objection to the notices that were sent. That,
Yes.
Mr. King may have some comments or objections about the proposed remedies that have been proposed by the city. But let's run through the photographs first.
Okay, this is Exhibit G1 from January 4th. I think this is what he was just speaking about, this window. I figured it was boarded up too, but apparently maybe it's just painted. I'll let him discuss that with you.
I don't think it's showing up on our screen.
It's not up there yet, sorry.
And for belt and suspenders purposes, Your Honor, I think Mr. King actually came in after you swore everyone in, I think.
Were you here to be sworn in?
No, I wasn't.
Okay. Well, remind me to swear him in before we take a step.
He'll swear you in a minute before you testify.
Okay, so basically this is Exhibit G1, it's finally up there, January 4th. You see the rotted, deteriorated siding, and what I assume was a boarded up window, broken or boarded up, but it may not be. says about maybe it's painted, we'll find out. This is the side of the house, again, some rotted siding, January 4th, 2023. And this is the front wall of the house, same thing, January 4th. And yeah, I guess if you look at it, it does look like it may be, I don't know if it's wood or glass, but it's definitely painted. That's pretty much what we have for you.
Okay. All right, give me a moment to review. Okay. I've reviewed the file. Mr. King, do you have, I know you don't object to any of the notices. Do you have an objection to the admission of the exhibits that were mentioned in Mr. Rowe's testimony being admitted into evidence?
No. Outside of the, I don't know if it matters, but the window's not broken, it's just
Okay.
painted. But I do plan to replace it.
But the picture itself, you agree is admissible?
Yes.
Okay. So, being that there's no objection to the admission of the exhibits into evidence, and based on Mr. King's stipulation of that fact, we will admit these exhibits into evidence this time. Is there anything else from the city before Mr. King testifies? Mr. King, before you testify, will you raise your hand, please? Do you swear to tell the truth, the whole truth, so help you God?
I do.
Okay. Mr. King, this is your opportunity to speak with me and tell me any objections you have to the evidence that was presented by the city. What I hear you saying is that the window looks like the front window, I guess it'd be the bottom right panel, you're saying it's not boarded up, it's painted. Is that correct?
Correct.
Okay. Is there any other dispute you have with the evidence that has been presented by the city code enforcement?
No.
Okay, thank you. Mr. Rose, do you have, let me ask you, any other statements or any other thing you want to say regarding this matter? You understand the city's asking for a fine of $100 a day, retroactive back to, I think it was April 16, 2024, is that correct?
Yes, sir, but he's got a dumpster out there. We would be fine if you want to push that further out into the future.
Okay.
But I wanted to let him
Okay.
request that from you.
Thank you. So you understand, right now, the city's position was, because you were ordered to come into compliance by the 16th of April, and there's still some non-compliances, that they are asking for a $100 a day fine dating from April 16th through today, and to continue until that compliance is until the property comes into compliance. But is that something that you would like to object to?
Yes, I was just waiting. I don't know when I could do that.
Okay.
But I definitely would like to object to that. I just need a little more time. I had the budget to make the repairs. However, I found some compromise in the roof, so I had to get to protect my interior. I spent my budget on the roof. I did order a new window on April 8th. Should be 6 to 8 weeks to come in. I think we're at about 5 weeks now. So I was going to request about another 90 days to come into compliance, just in case. I plan to do it in 30, but I just wanted a few days extra in case the window comes in damaged.
Well, we certainly wouldn't want to set you up for failure, you know, and create an unrealistic timeline. Mr. Rose, do you have a comment on the number of days that have been requested for an extension, essentially?
No, so that'd be fine, as long as there's a permit in place and, you know, he gets it done within the 90 days, that, our goal is the same thing, so.
Right, okay, all right. So what we'll do is we will not impose a fine at this time, give you 90 days from today to come into compliance, and we will adopt the findings that are contained in the proposed order. Make sure that you get your proper permits and notify the city when you think everything is done so they can re-inspect and get this thing put behind you, okay?
All right, thank you.
All right.
2 points of clarification, Your Honor. So at the end of the 90 days, are you ordering that the fine start accruing if he has not come into compliance?
Yes.
Or you?
Yeah. That's a good point, Mr. Burns. Yes, you order that a $100 a day fine accrue if it's not remedied within 90 days, okay? Is there any?
Administrative fee too?
Yeah, administrative fee of $325 will be imposed, and that's payable in 30 days, okay? Can you pay?
For today?
Yes, for the proceedings today, can you pay the $325 in 30 days?
Yes. I do have a question, because my last hearing, I had a fee. I have logged into the website under my profile. It still hasn't populated.
Okay. Well, you paid a fee the last hearing, and of $325, is that correct?
No, it hasn't populated. I've been checking, because I just had my roof closed out. The roof is complete and my permits are closed, but periodically I've been checking during the roof process my profile to pay the last fee that was imposed.
Okay, so you currently have pending a $325.
Right, I do have a fee that has not
Okay, so we're gonna make it $400. We're gonna have $50 for that fee for today, okay? Payable within 30 days.
Okay.
So just one fee for the
One
two
fee,
hearings?
yes.
Okay, so you're not getting a second $325.
Thank you.
Yeah.
But I think that was a $75 increase.
It's a $75 increase. No, I don't want to make it 50. I'm sorry. I made the same mistake, Mr. Burns, as at 350.
Yeah.
So 375 will be the total for both of these hearings. So today's fee is $50. The prior fee is still $325. Okay? Payable in 30 days.
Thank you.
Okay?
And, Your Honor, I guess if I could just add one thing, can he, since we're still on the record, Bert, is there a way for someone to walk with them over to the, I guess, whoever takes payments here at the city and get that paid, since he indicated it hasn't populated yet, and maybe?
Yeah, we can help him out. We'll have to put it in the system first. It's not in there right now.
Okay.
The 325 will be sitting there, but we'll have to figure out how to get the 50 in there, and then.
Oh, I guess he's indicated that the 325 is not sitting there yet, though. He's indicated on the record that,
It should be. I'm not sure how it works with this new MGO program we're utilizing, so if it's not, we'll get that in there also.
okay. Is there someone he could walk with right now, I guess, to do it?
Not at the moment, 'cause
Okay.
we're all gonna have more cases to hear, but shortly after the hearing, we could.
And I don't know if Your Honor wants to ask the respondent to sit around and
Yeah, I was going to say, if you want to stay here until staff is done with these hearings, then you can probably get that matter taken care of today with their help. Is that something you want to do? It's up to you.
We can come back
Or you
tomorrow
come
morning
back.
as well,
Right.
either way, whatever.
I travel from Panama City, so
Oh.
I'll stick around. It's no
Okay,
problem.
okay. Well, we'll just have a seat, and staff will be with you as soon as they can,
Right,
okay?
thank you.
Is there any one from the public to be heard on this case? All right. Is there anything else we need to address in this matter?
I don't think so.
I don't think so. All right.
Next case should be agenda item 8.4. This is case number CE 23628 UNO. This case pertains to 224 Bradley Drive Northeast. According to the tax records, the owner of said property is Janet L. Collins. This property was originally found in violation 140 days ago on December 27th, 2023. This case was brought before the special magistrate on March 20th, 2024. The magistrate found the property in violation of Code Section 50401, 1, 2, 3, 4, 5, 6, and 7, and 50402, 2, 4, 6, 7, and 9 litter, and Code Section 50401 and 50402, 9, and 10 unlicensed non-operative items. The special magistrate issued an order giving the respondents until April the 9th, 2024 to bring the property into compliance. An inspection of the property on April the 9th found the violations had not been corrected as ordered. Therefore, on April the 30th, 2024, a statement of non-compliance was filed. On May the 3rd, 2024, service was obtained for the notice of hearing. At this time, staff would like to enter the exhibits into the record. Exhibit H is a March 20th, 2024 order of the special magistrate. Exhibit I is the April 30th, 2024 statement of non-compliance. And Exhibit J is a notice of hearing and proof of service. Staff is requesting issuance of findings of fact, conclusions of law, and issuance of Order 2, including a $325 administrative fee. Staff recommends a fine of $100 per day, starting on April the 9th, as previously set out by the special magistrate. And we do have a respondent here. I believe the gentleman is the occupant. Is that it? Sir, you want to look at copies of the notices we sent you? Do you have any objections to enter into the record photographs of the last one?
Yeah, I was going to say where it was.
And then after we review the file, you'll be able to testify and see some of the previous.
No objections.
No objections there.
For the clarification of the record, the agenda has 626, but the case number is actually 628.
That's probably me when I put it in.
Typo.
Thank you, Mr. Rhodes. Mr. Moore, did you want to publish the photographs?
Say again?
Yeah, photographs.
Yes, sir, they should be on the inside cover. I mean, on the last page on the inside cover.
Okay.
I'm glad the occupant is here today because he has been making progress on the property. He's cleaned up a lot. I believe he said today the truck's up and running. I just got to verify the tags current. And we do recommend the Order 2, but since he showed up today, I don't have any objections to an extension of time before a fine starts, depending on how much time he may need to get it compliant. 'Cause he has been working on it.
Thank you. Okay, give me a minute to go through the file. Special magistrate finds that everything in the file, the exhibits are in order. There's no objection to admission of the exhibits in evidence, so we will admit those exhibits without objection. Is there anything else from you, Mr. Moore, from the city?
No, sir.
Thank you. Please state your name.
James Collins.
Okay, and Janet Collins is?
Janet Collins is my mother.
Okay, all right, and you're here on her behalf?
Yes, sir.
Did you appear at the prior hearing on her?
No,
behalf?
Your Honor.
She appeared?
No,
or
Your
not
Honor.
appeared? Did she appear?
No, Your Honor.
Okay. Did anyone appear on her behalf of that?
No.
Okay, thank you. All right. You've not objected to any exhibits, so, but I assume you have some evidence or some statements you'd like to make to the.
Yes, sir. I couldn't work or walk for the last 8 weeks because I had a blood infection in my heel, is why I haven't finished it yet. Is there a way to put a car cover or a vehicle cover over the truck and not register it?
I'd have to defer that question to code enforcement.
Technically, the code does not allow for a car cover to comply the violation. It doesn't prohibit anyone from using a car cover, but if it's already identified as non-operative, they do need to show that it's operable with the current registration before we can comply the violation.
Okay, do you understand that answer?
Yes, Your Honor.
Okay. Do you have any other comments, questions?
I'd like to request an extension.
Okay. Given the fact that it appears that the city agrees you've made a good faith effort to comply with the prior order, and sounds like you've had some health issues that have hindered that ability to do so, we will, at this time, give you an extension of time to do so. How much time do you think you need to address this?
90 days.
Is there any objection, Mr. Moore, to 90 days?
No, sir.
Okay. So we'll essentially do what we did in the last case. We'll extend the time frame for you to comply to 90 days. Was there how much of a administrative fine?
That was my next thing, is I haven't worked in so long that anything will hurt me, so I need more than 30 days for the administrative fine.
Okay, was the $325 imposed at the last hearing? I assume it was, since no one objected. Okay, so what we'll do is impose an extra $50 administrative fee for today.
Thank you.
That will bring the total administrative fee to $375, if my math is correct this time. And we'll give you
Real quick, Your Honor, the fines will start accruing at the 90-day mark, like the last hearing.
Yes, just like the last order,
Okay.
Mr. Burns. So, yeah, understand that after that 90-day period, the extension, that the fine of $100 a day would start to accumulate. So please make sure you address this as early as you can. We want you to succeed, not fail.
And this is my first time I've been here, so shouldn't it just be the 325 administration?
Because there was a hearing.
Oh, even though I wasn't here? Okay.
Yeah, the last time.
Understood.
Instead of another $325, we're just going to impose another $50 for that.
Understood.
And we'll give you 60 days to pay that administrative fee. Anything else we need to address, Mr.
Do you mind if I just inquire, because I guess he's not the property owner himself, just, is there a reason your mom has not appeared here?
Yes, she's in a home and she can't walk.
Okay, okay. It's just, and you're residing there?
Yes, sir.
Okay.
Thank you. Anything else you have to add?
No, Your Honor.
Okay. Is there any public comment? Okay. There being no public comment, this case is concluded for today. Thank you. Have a good day. I think that. Yes. Okay, I think the next case is 8.5, if I'm correct. Case number CE 24140OL.
That's my mistake. Agenda item 8.5 has been complied.
Okay. So 8.5 has been retroactively removed from the
Yes,
agenda.
sir. They applied for their license. They're good to go.
But I approve that if I need to. Okay, the next one then would be 8.6, case number CE 2438MXN. Mr. Rhodes?
Okay. Robert Rhodes, Code Inspector, City of Fort Walton Beach. This case is CE-24-38-MAN. This case pertains to subject address of 369 Canterbury Circle Northwest. According to the tax records, the owner of said property is Jolyn Carnathan Trustee. 118 days ago, on January 18th, 2024, the property was found in violation of Maintenance General Section 5.07.01 for failure to repair and maintain structures on the property, including the siding that was damaged and deteriorated. On February 29th, 2024, service was obtained for the notice of violation. On April 2nd, 2024, reinspection found the violations had not been corrected. On April 9th, 2024, service was obtained for the notice of hearing. On May 1st, 2024, photographs of the violation were taken, and as of May 15th, 2024, the property remains in violation. At this time, staff would like to enter the exhibits into the record. Exhibit A is a case history report. Exhibit B is a list of exhibits. Exhibit C, notice of hearing and proof of service. Exhibit D is a notice of violation and proof of service. Exhibit E is a copy of the inspector's qualifications. Exhibit F is a copy of the tax record showing the property's ownership. Exhibit G are the photographs of the violations. And staff is requesting acceptance of the findings of fact, conclusions of law, and issuance of Order 1, including the $325 administrative fee. Staff recommends 30 days time for compliance of the violations. This would make the compliance deadline on June 14th, 2024. And I don't believe we have any respondents here. So we can go ahead and enter the exhibits into the record.
Just for the record, it does not appear that there's anyone respondents here for this matter. Okay, having reviewed the file, there being no objections to admitting it into evidence, the exhibits will be admitted into evidence. The special master will adopt the findings of fact set forth in the proposed order and in the exhibits. We will set a date. We'll enter Order 1, setting a date for compliance to be June 14th, 2024, and thereafter we would impose a fine of up to $250 a day for each day of the violation that continues beyond June 14th, 2024. We'll impose the $325 administrative fee to be paid in 30 days. Anything else we need to address at this time, Mr. Brown?
Public comment?
Public comment. There be no public comment. That is the order of the magistrate. Okay. Moving on to 8.7, case number 2449WS, the litter case seeking an order 2.
Rich Shaler, Code Enforcement, City of Fort Walton Beach. This is CE 2449-WS. Case pertains to subject address 33 Lorry Drive, Northeast Fort Walton Beach. According to the tax records, the owner is Lance E. Brown. This property was originally found in violation 113 days ago on January 23rd of 2024. The case was brought before the magistrate on March 20th, 2024. The magistrate found the property in violation of section 10.51.04, connection to water service required. The magistrate issued an order giving the respondent until March the 30th of 2024 to bring the property into compliance. An inspection of the property, which was actually the water records, on March 30th, 2024, found the violations had not been corrected as ordered. On April 2nd, 2024, a statement of non-compliance was filed. On April 30th, 2024, service was obtained for the notice of hearing. At this time, staff would like to enter the exhibits into the record. Exhibit F, list of exhibits. Exhibit G, the case report. Exhibit H, the March 20th, 2024 order of the magistrate. Exhibit I, the statement of non-compliance, and Exhibit J, notice of hearing and proof of service. Staff is requesting acceptance of findings and facts, conclusion of law, and issuance of an order 2, including a $325 administrative fee. Staff recommends a fine amount of $100 per day, starting March 30th, 2024, the date previously set by the magistrate. And there's no respondent here today.
Special master will note for the record that there's no respondent here today. If I can review your file.
Mr. Special Master, Magistrate, just for sake of straightening something out on cases going forward, I did say earlier 30 days from the date for the admin fees.
Yes.
But the way it actually reads in all of our draft orders is the first day of the month following this hearing. So from here forward, don't put the 30 days in.
Okay.
We'll have to amend all the orders that way.
Okay, I'm sorry.
That's all right. That was my fault actually, because you asked me 30 days and I said yes.
Yes, no, yeah, please going forward, if I misstate or something, don't hesitate to let me know.
Yes, sir.
Okay. Okay, I've reviewed the file containing all of the exhibits. I find it to be in order. We'll admit it into evidence. It's unopposed. We will, a fine of $100 a day will be imposed dating back to March 30, 2024. And it looks like the order as drafted as an order will adopt the findings of fact set forth in the order and the exhibits. Anything else? Public comment? There being no public comment, that'll be the order of the special magistrate. Get your file back.
The last case should be case, agenda item 8.8. This is case number 15-1254. My name is Ed Moore, Code Inspector, City of Fort Walton Beach. This case pertains to 69 Lower Drive Northeast. According to the tax records, the owner of said property is Leslie Fagan et al. On January 13th, 2016, the property was found in violation of Code Section 50401S grass height, Code Section 50401, 1, 2, 3, 4, 5, 6, and 7, and 50402, 2, 4, 6, 7, and 9 litter, and Code Section 50401 and 50402, 9, and 10 unlicensed non-operative items. This case was heard by the Code Enforcement Board on January 13th, 2016 and March the 9th, 2016. At that time, the Code Enforcement Board ordered the respondents to comply with the violations by January 28th, 2016. The respondents did not comply as ordered. A fine of $100 per day has been running since January 28th, 2016, and as of today has accrued to an amount of $176,100. In addition, administrative fees in the amount of $650 have been imposed on the property that have been left unpaid. As of today, May 15th, 2024, the property remains in violation due to the lack of compliance by the respondents. Staff is requesting the special magistrate to authorize the city attorney's office to proceed with foreclosure.
Is this the Fagan case?
Yes, sir.
Okay, and while you're reviewing the exhibits, Mr. Patrick, was there a lien actually entered in the public records previously? Do you have the book and page number of that? Because I couldn't find that.
Yes, sir. What had happened, if I could make it short, Dana Fagan et al. Was the owner. And I believe that's Leslie's brother. I believe he we went through this whole process with Dana, got the lien.
I mean, to
yes,
simplify things. And sorry, because Matt and I actually talked about this beforehand, and I put my hat back on representing this side now. So I guess the biggest thing, the statute requires under 162.09, you first have to file a certified copy of the order, and then 3 months after that's been filed in the public records, then the request can be made to the board or the magistrate in this situation to then proceed forward with the recommendation of council to do the foreclosure. And so we're just trying to find, do you have a copy of the order, book and page number?
Should be in the file. I think, back then, I believe we recorded everything, a certified copy, and then I believe the city clerk's office for a short time didn't, but now we do, and with other foreclosure cases we've had, if the order wasn't a certified copy or certified, whatever that entailed, the city clerk has been able to rectify that.
Yeah, I did see a recorded copy of the action on statement of noncompliance, second order. Mr. Burns at book 3240, page 1. 3240, I'm sorry, page 682.
And does that, since I've not seen that copy, Your Honor, is that copy certified?
Yeah, it is actually certified as a true and correct copy by, I assume, Ms. Barnes, the city clerk.
All right, good, because we just didn't have those in front of us beforehand, so that's the...
Okay. So from that standpoint, I think that's in order.
And I guess just because this was an issue at the last one of these we did last year, which was kind of my first code enforcement matter for the city, but was notice provided to the individuals at the property, because remember they came in and made a big deal about that.
Yes, sir. I sent out a notice of foreclosure 30 days prior to the hearing, certified mail, regular mail, and I posted the property.
And you got copies of all that back, like showing?
I didn't receive a certified back, but I did take a picture when we posted it. I did an affidavit.
And so the certified, you have a tracking number on that, though?
Yes, sir. It's in
and so you could like type that in?
And check it. Yes, sir.
Okay.
Okay. And I do see a formal notice of intent to foreclose addressed to Donald C. Fagan et al., dated April 18, 2024. And that was posted.
Yes, sir.
And sent certified mail, but you had not received the receipt back on the certified mail. Is that correct?
No, sir. The history with this case has been that basically certified mail just, they don't, lays unclaimed, and then we have to post it. So that's why I posted certified and regular mail.
And in your honor, because you weren't here for the last one of these we did, the board was still in existence at that time of hearing these. I believe it was maybe August or September of last year. And because these are recorded on YouTube now, I just feel a good inquiry. So anyone who in the future comes and looks and says, did we treat these people fairly, would be in order. And so do you mind me asking a few questions, Mr. Moore? And I'm not trying to trick you up on this. So Ed, when you went up to the property and posted it, was anyone there you could tell?
The times I've been to the property to post it in to take pictures, there's been a truck there off and on. I usually knock on the door and see if anybody's there to communicate with them what we're posted on the property. Nobody came out, but I have learned from neighbors that Leslie is still living there.
And you said there's a truck that comes and goes, just because if they end up challenging this in the future, I'll watch the YouTube and go, well, there was this color truck. Do you remember what color truck?
I want to say it was a brown Chevrolet.
Brown Chevrolet, okay. And so that truck has come and gone the number of times you've been there, so that clearly someone has removed the truck and brought it back at times, correct?
Yes, sir.
And the neighbors that you spoke to said Leslie, the owner, does live there?
Yeah, exactly. I spoke to her the other day, and the neighbor at 74, Lori, says that Leslie is still living there.
Okay. And Your Honor, thank you for indulging me on going above board on what really would be required in this situation. I just want to make sure when they come in and say we didn't make an adequate inquiry that we can show that we did.
I appreciate that, Mr. Burns. Okay. Anything else from?
No, sir.
And there's no one here on behalf of the Fagans, it appears. Okay, I've reviewed the file, the exhibits, I've heard the testimony of Mr. Moore. Based on that testimony, we'll find that everything is in order in the file. The exhibits will be admitted into evidence without objection, and the special magistrate will enter an order authorizing the city to proceed with foreclosure. Any public comment regarding this matter? There being no public comment, that will be the order of the court. Thank you. Okay. I think that concludes our agenda today, if I'm correct.
Looks so, sir.
Anything further from the city?
No, sir. We thank you very much.
Thank you, and we'll call the matter.
Okay.
Do you have anything for us?